All right, so there does seem to be a pretty interesting story here. It says that Utah ban on trans girls in school sports blocked amid legal challenge. So what has happened is a preliminary injunction has been granted in favor of transgender girl plaintiffs. I think three of them in total. A judge has granted a preliminary injunction against, I believe it's House Bill 11. I believe we'll find out here for sure in a second. This is a statute passed at the state level by the Utah legislature that was they actually overrode the governor's veto, Spencer Cox. So he actually vetoed it, and but the legislature overrode him. And so yeah, it says a Utah judge on Friday blocked a state law banning transgender girls from participating in girls' school sports from being enforced, while it considers a lawsuit by three transgender students challenging the law. Utah state legislature passed a law earlier this year, arguing that it would help protect athletes and ensure women were not edged out of their sport. But Judge Keith Kelly of the 3rd Judicial District Court in Salt Lake City ruled that transgender girls did not necessarily have an automatic advantage over other girls, since puberty blocking treatments can prevent them from developing the physical advantages for sports that boys can have. So I believe this is a Utah level court and not a federal court. I really hope that I'm not getting that wrong. That'd be so embarrassing. So what it says now is basically now that the statute has been temporarily blocked, now there's a new system that will be in place that was actually also passed in anticipation of a preliminary injunction towards their law. And so it says with the ban blocked now, Utah law states that transgender girls' eligibility to participate in girls' sports will be decided by a state-created commission on a case-by-case basis. And so that still sucks because I guess it means it's like you're guilty and have to be proven innocent kind of situation is what it seems like to me, unless they're doing it in the reverse. But it's supposed to have like a statistician, like a medical person and that kind of stuff on it, so there's supposed to be a bunch of experts. Now, I was actually really curious about what the actual reasoning for this case was. On what grounds does the judge issue a preliminary injunction? On what grounds can the judge say, I'm going to block the Utah statute, the Utah legislature statute, the state level Utah statute that is, banning transgender girls from, playing in girls' sports? And so after some looking, I'm shocked. I was actually able to find the actual text of the preliminary injunction here, order granting plaintiffs' motion for preliminary injunction, Judge Keith A. Kelly. And so one of the things also, I don't know if y'all remember, two of the things that I just talked about yesterday or a couple days ago in my video in which I was talking about the situation with the Anti-Woke Act in Florida being also partially banned. Remember I told you guys that, I told you guys about the different scrutiny levels. There's strict scrutiny, there's intermediate scrutiny, and rational basis test that's applied to statutes to determine their constitutionality. That's going to come into play. And then also, remember I told you that you actually have to prove that you have personal injury in order to be able to bring a case. And so actually like a week or two ago, I think, basically the Utah Attorney General was trying to basically say like, these girls don't have standing, they can't prove personal injury. But the judge says no, they have suffered irreparable harm, and so they do have personal injury, and ergo, because of that, they have the standing to bring a case. You have to have standing to bring a case. You can't just go and challenge a law and be like, this is against the First Amendment. You have to be like, no, this statute chilled my speech. That's what you have to be able to do. Anyways, so basically what it says is it has these four things in terms of establishing a four-part test for specifically obtaining a preliminary injunction. It says the applicant will suffer irreparable harm unless the order or injunction issues. Threatened injury to the applicant outweighs whatever damage the proposed order or injunction may cause the party restrained or enjoined. The order or injunction, if issued, would not be adverse to the public interest, and there's a substantial likelihood that the applicant will prevail on the merits of the underlying claim, or the case presents serious issues on the merits which should be the subject of further litigation. So basically it says like there is a good chance that they would actually be wrong, and what they're citing is actually they're citing the Utah state constitutions. I don't know if you guys know this. States have their own constitutions. We all know the U.S. Constitution, that's the federal government's constitution, but originally it actually only applied to the federal government for I think like 60 years or something like that. I think until the 14th Amendment in the 1860s. Or later on, sorry. But Utah's constitution has a uniform operation clause. Says the court finds that plaintiffs have shown a substantial likelihood that the ban violates the uniform operation of laws (UOL) clause of the Utah Constitution, which provides, quote, all laws of a general nature shall have a uniform operation. It says this clause is a state law counterpart to the federal equal protection clause. So that's a clause of the Utah Constitution, basically saying that it is in violation of this, and it lays out all the information here. I'll leave a link to this down below so you can read it yourself. I'm not going to get too super into the weeds of this, but basically it just goes through every step, and it says, hey, there is standing to sue. This is discrimination. And so basically what it ends up going on to say here is, check this out. So what it ends up saying here is, 3, if there's disparate treatment, whether the legislature had any reasonable objective that warrants the disparity. And this is the third and final step, quote, incorporates varying standards of scrutiny. Relevant here, where a statute discriminates, quote, on the basis of a suspect class, heightened scrutiny applies. So heightened scrutiny is synonymous with intermediate scrutiny. So remember, rational basis test, intermediate/heightened scrutiny, strict scrutiny. So like I said, in a lot of discrimination cases, it's intermediate scrutiny that is applied. So in this case, intermediate scrutiny is applied. The government has to prove that there is like a serious government interest, and it's being the least, I think, burdensome, or the least like discriminatory way, and like it serves like a serious interest. And basically what he says is it doesn't do any of that. There's no actual evidence of threat, because pretty much the law itself, like there's like, I think, I don't know, like one or a few girls before the law was passed. I think there was one trans girl who was playing in girls sports, and there's no evidence that there's like this big amount of trans girls in girls sports even in the first place. And then secondarily, as is broken down in this preliminary injunction, the judge basically says that there's no serious advantage over biological girls because of puberty blockers and hormonal changes that are taken for, which are used for treatment for gender dysphoria. And so he basically says that there is, and he cites a study saying that there is no serious differential between a boy and a girl pre-puberty in terms of strength because of the hormone testosterone, which really boosts up at puberty, right? So what he's basically saying is these are basically young girls who are essentially have been getting actual care, and he cites that in here too. They've gone and been diagnosed with gender dysphoria and have been getting these kinds of things, and it says that it discriminates against them because they don't actually have a big any kind of big advantage over biological girls. It says the ban creates a sex-based classification that does not withstand heightened scrutiny. Third step of uniform operation analysis considers if there's disparate treatment, whether the legislature had any reasonable objective that warrants a disparity. So basically, it just says that it doesn't end up meeting it because there's no actual reasonable necessary further legitimate legislative goal. There's no threat, and so you have to prove that there's some kind of like serious issue going on, like maybe. I think the example that they show in this one is like, women's sports, like banning, not allowing men in women's sports. It's like, women have, historically had less opportunities than men in sports. And so that's something that can be, that you can use in terms of being a government interest. But in terms of this, it just doesn't make any sense. So pretty interesting to see some of these terms coming in, and this is just a preliminary injunction, so it's just a temporary pause. We'll have to see what happens in a more long-term sense.